So as we enter into the last portion of the day, we're going to provide global comparative, as well as talk a little bit about what does the future hold. America's favorite pastime used to be baseball. So we did the 7th inning stretch, and now here we have our home run and our hitters here for this presentation. And just wanted to say a small thing about myself. I have spent 20 years in local government in the city of Philadelphia. And I am the public administrator that thinks FOIA is an ankle biter. And I'm dealing in my day where I came from, at the school district of Philadelphia as the chief operating officer most recently. Kids are setting trash cans on fire and teachers want to go home for the day. And I'm saying, no, you got to get back to school. We had a bankruptcy proceeding with a transportation company that we were facing in 2 weeks, potentially 10,000 kids wouldn't have yellow bus transportation. We had a structural underpinning in one of our schools and had to open school a week late and start school a week late the first week of school, and you're really judged on your first day of school in the school district. And then, next thing you know, I had to be an expert on lead and water. So when it comes to, you get an email that says, provide all of the emails that you've covered on such and such an issue because your right to know attorney has just gotten that request, it's the last thing you really want to be dealing with. So a lot of what we've heard about today is certainly competing priorities, competing resources, and really the demands on government, and also the necessity and the importance, frankly, of public sector transparency and the challenges that come with it. So with that introduction, I am honored and privileged to turn over to Dr. Suzanne Piotrowski, one of the definite brilliant minds here in the country, and get her started for our third panel.
Great, thank you so much. Thanks everybody for staying. I know it's a long day. As we mentioned, we're doing a little bit differently. We're branching out in this panel, so we're talking about FOIA here, but I'm talking about FOIA in the context of open government, more broadly defined. And I should say, the punchline is I have more questions than answers at the end, but I at least bring it up, and we're going to try to just broaden it out a little bit. Sorry, let me just put my timer on here. So, what is open government? We'll start there. So I have one academic definition for you here, but I think probably the one that's a little easier to think about is what values are associated with open government. And we think about transparency, which is embodied by the requester model with FOIA. We're talking about proactive disclosure, data portals, that sort of thing. We're talking about collaboration, which is collaboration between units within an organization. So in the federal government, per se, you've got agencies collaborating with one another. We're talking about more networked governance, nonprofit, civil society, working with government. And we're also talking about citizen participation. Citizen participation in the aspect of participatory budgeting initiatives, citizen science projects, even something as simple as commenting on a proposed regulation. So we're thinking about open government, and it is broader than just FOIA, it's broader than transparency, it also includes collaboration and participation. I'd also say there's a heavy focus on technology in the open government movement. Okay, so there are a lot of folks here that know a lot about FOIA. They also probably know a lot about what's happened in the US with respect to open government, but just if you humor me, I'll just go over it very quickly. So the Obama administration, at least rhetorically, was really hot on open government, right? So the first executive order that came through was the Memorandum on Transparency and Open Government. I love this picture because at least the internet tells me this is actually Obama's hand while he was signing the first executive order. So I don't know, but that's what I've been told. So the first EO he did was on open government. And this led into this open government directive that really pushed all these values that I was talking about: transparency, participation, collaboration, heavy focus on technology. And one of the interesting things that I'm going to mention is that all the agencies were supposed to write these open government plans that were going to show what they were going to do with respect to furthering these goals. why I bring this up is because in a lot of ways, this was exported, this model was exported in the Open Government Partnership. Now, I normally ask who knows about the OGP or who doesn't. So does anyone, who here would say they're very familiar with the Open Government Partnership? Okay, a handful, right? So I should have also said I'm a professor of public administration. So you would think that my people would also know a lot about this very important international initiative. Nobody does, so you're not alone. I think this says something about the organization and its mission and its lack of resonance, that people don't seem to be responding to it or picking or really sort of running with it, at least particularly here in the US. I have given this presentation in other countries also, and there's varying degrees of recognition. But OGP, launched in 2011. They call themselves a platform, a multinational platform. I didn't look today to the number of countries, but it's something like 76 countries, member countries. 76 countries are members of the Open Government Partnership. And again, this platform, the idea is to promote transparency, fight corruption, energize civic engagement, and leverage new technologies. I should also say that why OGP is different than some other international initiatives is that it really does have parity with civil society. So when a government is a member, the civil society in that country is also a member. They sit on the steering committee together. They're on the working groups together. There's supposed to be co-creation of these national action plans with civil society and government. Not always the case, some countries more than others, but at least in theory, and that is new. So here is a picture of one of the initial OGP meetings. Should say there were 8 initial members. We only have 4 of them here, but it's a storied sort of group. But we've got Brazil, Indonesia, Mexico, Norway, the Philippines, South Africa, UK, and the US. And we won't do it here, but if you follow the stories of these countries, you know that there's really been, I think at best, mixed results with respect to open government in these countries. And these were the founding OGP countries. So I should back up and say the OGP was founded by these folks, but it really was spearheaded by the Obama administration, initially at least funded through Soros money. Now that's changed. They're basically out of the game, and the countries are providing money. They have dues, they don't necessarily pay them, but the countries are generally supposed to be providing money, and then there are some other funders as well. So what I'm arguing here is we need to think about the Freedom of Information Act within the broader context of open government, right? So there's this new paradigm going on here. It's broader than it's broader than freedom of information. And when we're looking forward with respect to FOIA, we need to think about and recognize this broader open government reform movement. So it's not just FOIA anymore, not that it ever was. None of these things are new, but it is a new package, and taken together, it is something we need to seriously consider when we're thinking about the future of FOIA. So when countries are joining, if they want to join the Open Government Partnership, they have to hit a certain benchmark, and there are these secondary data that are combined into this index. And why I bring this up in particular is because one of these is access to information. So how progressive a country is with respect to having an access to information, or FOIA law, is important to even getting into the OGP. So if a country's able to become a member, if they hit this benchmark, then they sign on to a high-level open government directive that says they're going to be more transparent, participatory, collaborative, et cetera. Then they also need to do national action plans. They're supposed to be every 2 years. And these plans are supposed to be co-created with Sorry about that. So it's a co-create. Hope someone's picking my son up at the bus. That's what that was for. Okay, so the national action plans are supposed to be co-created with civil society and governments. And then they also agree to be assessed. I wouldn't necessarily say graded, but how well the countries are doing on actually meeting the commitments they said they were going to meet is part of the process. This is called this independent reporting mechanism, part of the OGP. I should say it's a whole bunch of lingo, but it's the IRM researcher, the independent reporting mechanism researcher for the US for the second national action plan. They're currently moving on to the fourth national action plan. Okay, so why I bring this up is to talk about the role of freedom of information, or as it's more globally referred to frequently as access to information. So there's an access to information, or ATI, working group in the Open Government Partnership. They've come up with a list of commitments, a long list of commitments that deal with access to information in all 76 countries in all of their national action plans. And it's a big document. So, well, I just thought this was a little funny. As I was researching access to information in the OGP, if you'll just humor me for a second, they have these things called starred commitments. It sounds very silly. It kind of is, but what it means is that the countries have done commitments that could be transformative as well as completed, right? And so Croatia had one of the starred commitments on access to information, so we'll just bring it up here. And it was improving the legislative framework for exercising the right of access to information and to amend the Act on the Right of Access to Information. So, and our colleague from Croatia is probably going to talk about this a little more, but those are the sort of commitments that they're looking for with respect to access to information in the broader context of the OGP. I just want to go on briefly to talk about, I did assess in the second National Action Plan, not as my role as the IRM researcher, but I'm an academic, this is what we do for fun, I guess. Used a framework, which I won't get into too much here, but looking at how has the OGP influenced transparency policies in the US? Or what do these policies look like that are in the second National Action Plan? And while the rhetoric of the OGP is very innovative, I found that actually most of the commitments in the National Action Plan are exactly, or I should say the largest group of commitments in the second National Action Plan were ones that are exactly what you would think about, sort of traditional transparency. The framework is inward, event, and retrospect, but basically means ones from people from the outside are looking inside of government, things that happen at a period of time in the past, right? So that's what we think about FOIA generally, right? You're asking for something that happened in the past, one specific time for a document. So the biggest group of commitments in the second National Action Plan dealt with very traditional transparency, which is not probably what you would think, or maybe what the OGP had hoped, but actually this is only about 36%. So there was a large group of commitments that did all sorts of different things to varying degrees, and there was quite a bit of transparency and collaboration between agencies, between federal agencies, which I think is sort of a bright spot with respect to transparency in the federal government going forward, that there does seem to be some initiatives for agencies to work together with respect to information sharing. All right, so just some conclusions, and I look like I seem to be on time here, but I would say FOIA is operating in a new paradigm. We've had FOIA for 50 years, we've had collaboration, we've had participation, but this package of open government and an open government agenda is new, relatively new, and I think we need to consider the future of FOIA within an open government paradigm. I didn't talk about it too much here, but there is a heavy focus in open government on technology. And I would just caution us not to let the technology drive the agenda, which it does at times. You know, we get excited about a new app, a new interface, a new website, which is great, except the underlying data is not very good at all. So we need to think about, make sure that blockchain is not driving technology policy, you know, it's not driving transparency policy in the future, that it's really important, what's important. I would also say we need to think about how the open government agenda drives FOIA policy on the ground. So what I mean by that is that there are limited resources in the federal government as well as in civil society oversight capacity to deal with these things, right? And so the more they have to do, the thinner their spread. So we need to think about the open government agenda and how that affects FOIA implementation on the ground. And then I also would caution just to think about really what is the goal. Is it freedom of information, or is it democratic governments more broadly? And so when we're thinking about the future of transparency and open government in the US, to keep that in mind, really what is the goal? And I'll end there. Thank you very much.
Thank you. And President Obama, who, as you mentioned, was really in the forefront of the open government partnership, as we've also seen recently some letters penned from him to his first girlfriend, as shared by Emory University. So it's just an interesting how that there's a personal, private interest and public interest that really dissect and conflict when we get into the subject. Thank you. Dr. Anamarija Musa is, we are honored to have you, and she was appointed by the Croatian Parliament in 2013 as the Information Commissioner. And we're anxious to hear your experiences and the influence that you can share with us for the United States and some of the issues we've heard about and talked about through today.
Okay, thank you. Thank you. I want to thank the organizers for inviting me as a representative of others, so not American requesters or public authorities. So I will say something on European perspective on freedom of information, asking myself and you, are we ahead or behind you as the first country in the world that had a special access to information law, freedom of information law, although the Europeans invented it 200 and something years ago, but I would not say that this was the FOIA in the way we understand it today. It has some specific purposes for the media. So what I will talk about is, I will say briefly a few words on Croatia, so you know where is it, and I believe most of you know, but still, I want to just to go. It's a kind of marketing, and you know I have to do it. Yeah, I have to do it. Yeah. Then I will say something about legal and institutional development of freedom of information in Europe and European Union. And then I will show you on the example of Croatia being a star commitment, having many star commitments in the OGP. One of these commitments was establishing the commissioner. So what we did, and basically what most of the other European countries did, because what we see now is the convergence of models in Europe, because we learn from each other, especially within the EU. So about Croatia, shortly, I must keep my time. So it's in southern Eastern Europe. You can see it like there, across Italy. It's a newly independent state, only 25, 26 years. It had a war. It fought for its independence in the war. The population is 4.3 million, so it's a tiny state compared to any US state, basically, and especially United States in total. GDP per capita is slightly bigger than Russian or Mexican, but it's 3 times lower than United States GDP per capita. So just you get a perspective. It is a parliamentary democracy, and it has a civil law system. So in Croatia we have pretty much different system than the US, but still the other European countries mostly follow this path of parliamentary democracies with civil law, common law systems. So, but this will be important later, I will say why. We are the last member state of the European Union. We could be last forever, you never know. I think that the process goes now reverse way. And we have a capital, Zagreb, you might have heard of it, but I suppose you heard about Dubrovnik, which is a very old city-state, like a polis, Greek polis. But what is interesting that it had anti-corruption statute, provisions in its statute, 13th century, which actually required that all the officials have to be careful about their private interests, that have to report their conflict of interests, and have to act transparent in that, what at that time was considered to be transparent. Here is the a sign at the entrance of on the palace, which says, forget private affairs, tend to public business. And it was basically a motto of that time. So what about Europe? No, I have to do it right here. So shortly, at country level, almost all the European countries have freedom of information laws. As Suzanne already said, they're mostly called access to information laws, or right of access to information. This is because of basically what happened is that when we compare today's situation of legal frameworks in Europe to basically the source of freedom of information in Europe, which is European Convention on Human Rights, and its Article 10, which grants freedom of expression. The difference is that today, right to information is a separate right. It's not anymore only a part or pertinence of freedom of expression. So now, not only most of the countries have the law, most of the countries also have included the right to information, right of access to information into their constitutions. So in 2012, there were 19 countries. There could be a few more after that, but one group is Scandinavian countries, which have this tradition of transparency, and the other groups are Eastern European countries, which basically introduce this right as their constitutional right in order to strengthen the enforcement mechanism. Of course, if the right is constitutional right, it's much more important than if it's not. In the European Union, we also have a new right, access to information right, in the Charter on Fundamental Rights of the EU, which is a kind of constitution of the EU. This is new from 2009, and we also have a special regulation on environmental information and on the open data. So what I want to say is that in Europe, the legal framework, both at the European level, Council of Europe level, and the different countries, is becoming more and more sophisticated and specialized, especially within special jurisdictions. And here I showed you rating of the laws, which is done by Access to Information, NGO, global NGO fighting for access to information, which says that out of 10 best laws, 4 are tiny countries from Europe laws, I would say so. So it's Slovenia, Croatia, Albania, and Serbia. First is Mexico, which is interesting too. The other thing I wanted to say about Europe, and we talked about today about this protection mechanism, should it be a specialized court, specialized judges, or alternative dispute resolution mechanism, as it is now, or nothing, basically. In Europe, depending on different factors, I would say these were political and legal culture, so tradition of transparency, the existing context at that time, at the time when the special legislation was adopted, different external or internal factors such as civil society pushing for more transparency, or European Union pushing for more transparency, as it was in Croatian case, because we adopted a new law just before we entered into the EU. So it was a kind of a condition for us to get there. And depending on the level of privacy protection, we have basically 3 different institutional models. One is recent time not very democratic either. The second type is these countries where the access to information right is viewed as a kind of information right, together with privacy and other information rights. In these countries, there's an independent authority which combines protection of privacy and protection of transparency, which is a hard task. You have to admit, you're fighting for two different things, to release or not to release. So it is the situation in UK and Germany and Switzerland, and again, it's some Eastern European countries, Slovenia, Malta. But what is interesting that in most of these countries are regarded as very good in protecting both privacy and transparency. And there's a third group where we have commissioner or commission dealing only with access to information, or maybe with other transparency initiatives like public consultations or this is the Croatian case, but also France, Italy, Spain, Belgium, Ireland, and Scotland. So for the ideas, I knew that you might be interested in that. So with regard to Croatia, I have to say that in 2003 we adopted the US model, basically. So there was no special administrative appeal, but the requester could challenge the decision of the public authority directly before the court. I'll not go into the details within this law, but this law proved to be ineffective, and it did not grant any. It basically did not lead to the greater transparency. That's why in 2013, within the OGP, we introduced a new law. This new law basically was adopted within the OGP framework in collaboration of ministries, like Public Administration Ministry, government, NGOs, academia, media, and we all sat together. I was a part of a working group then and discussed about the new law. And there was a big role of civil society pushing for better law which could grant greater transparency. So when we the other thing related to this law is that it was adopted just after we introduced the access to information as a constitutional right. That's why we had to basically adopt a stronger law which would enable this right to be exercised at a certain level. And the third thing, maybe most important, I forgot maybe to say around was telling about congressional oversight. So given the fact that Croatia's parliamentary democracy and many other European countries, most of them, either parliamentary democracies or semi-presidential systems, parliaments have a really big role in controlling government. That's why many European countries are inclined to introduce so-called institutions of integrity, being ombudsman, conflict of interest or ethical commissions, access to information commissions, and similar institutions which are independent in terms of budget, appointment, government control, and similar. That's why we also opted for this kind of institution. So if you look at this appeal mechanism, earlier we had there was no administrative appeal which would be out of institution. Now we have the information commissioner. The commissioner, of course, is controlled. Its decisions are controlled by High Administrative Court, where both claimant or the requester and the public authority may challenge the decisions or report the commissioner for being silent, which happens a lot, unfortunately, because we also have big backlog, of cases, which I will show later. Beneficiary can be any natural or legal person. We were talking about today a lot who are the requesters. When you look at, so for example, in Croatia, being a country of 4.3 million people, the public authorities report that they receive 20,000 requests per year. This is some kind of steady number, 19 or 21, it goes somewhere like this. We receive 600 appeals per year. But when you look at the decisions, so we did this, so I won't go into details, but for example, only 70% of all denials come to us as appeals. So sometimes citizens just take it as it is, saying, okay, I will not get information, so I'm done. I'll not lodge an appeal. What is also important that 75% of all appeals are submitted by individuals. Media is only 2%. Because of their way of work, they're not interested that much when the issue is not very important anymore, and similar. And what is also important, we deal a lot with micropolitics and personal issues, unfortunately. I would like to see more of real public interest coming out of these issues. The other thing which is maybe different than US situation is the scope of the law. In Croatia, the law covers any public authority, including the president. We have a president too. Parliament, government, even us. So everybody is covered. Judiciary, local governments, all the agencies, schools, boards, anyone. So we have a list of all public authorities. We created it. It never existed before. It took us more than a year to create the list. But this, of course, this list is not closed. Any authority that appears out of somewhere, which we didn't see existed, then can be also added, and basically we do it all the time. With regard to exclusions, I also have to say, which I didn't know that basically for the US case, is that own records are not subjected to the Freedom of Information Act. According to Croatian law, and this is the situation in most European countries, when you're requesting information that concerns you as a citizen, no matter what, veterans, social security, any issue that is your own issue, then the other legal way is actually used. This is a privacy legislation or special laws such as, for example, patient protection law, medical records law, similar. But also, we also don't deal with the intelligence information. I like it, I have to say. Our procedure is completely free of costs. That's why we receive lots of appeals and we have lots of lawsuits in front of the court. So it's completely for free. There's no any fee, and people usually don't use any legal advice, so they do it all by themselves, and we do it all by ourselves. And we report to the parliament, I also have to say that. So what we do, we cover access to information on request and proactive disclosure. We cover reuse of public sector information, so both request and proactive publication are open data. We cover public consultation process and publicity of sessions. And we deal also with appeals, inspections. We have investigatory powers. We can go to the office or to the place. We also have IT guy with us, so because we don't get a lot all these things. We act upon petitions by any concerned citizen. We monitor by ourselves, doing analysis, who publishes what and when. And we do a lot of education and training, both towards the both of public authorities and the requesters. So these are our numbers. Just I told you most of it. Alina mentioned that if you took the number of reviews you do now, it took you 20 years or 30 years. That's the same. Basically, I also would say that because at the Information Commissioners conference a month ago in Manchester, we all said that nobody is, all the independent authorities are basically understaffed. They don't have capacity to basically cover all the authorities. We cover 6,000 authorities, and we have the office of 12, I have the office of 12 people. With all other issues we have to deal with, you know, when the, I don't know, water is broke or something happens in the office. So we deal with all of it. So these are our numbers, and as you can see, we have a big backlog, 635 appeals last year, but more than 1,000 open cases. So this was all I had to say now for today, but given today's discussion, I just want to underline that what I see every day in my everyday work is that what we lack here is the dialogue. So what I face with dealing with public authorities and also by the users is that simply they have hard time to put themselves into the shoes of the other party. So public authorities are hugging their information.
Mm-hmm.
This is the expression it's used now in open data slang. So like they're like, oh, we don't like this information to be misinterpreted, that the user don't use it against its purpose or something like that. On the other hand, the users or requesters believe that the government is negative and that they are hiding something. So basically, the problem is to get them together and to get them, to educate them, to train them, to be able to understand that sometimes you just have to let it go at any of these sites. So thank you.
That's okay. Thank you very much. And now we're going to hear from Richard J. Peltz-Steele, Professor of Law, University of Massachusetts School of Law. And just we have a little time of questions at the end. I'm going to give you a 2-minute warning when we're just about 10 minutes in.
I have my little timer running, so.
Excellent.
All right. Michael from Judicial Watch, is he still here? Michael's not. Michael left. Good, we can talk about him. Michael said if we really want to make this thing work, we have to blow it up, right? So, at risk of being barred from my plane tonight, I want to blow it up. And I want to suggest to you that in freedom of information and access to information, in those terms, there's no mention of government. It's freedom of information, freedom and information. And I want to ask you to imagine if a person could walk in and make a request of a corporation, and that were as ordinary as making a request of government. What would that look like? So to figure out how to work this thing. To a practitioner in the United States, that might seem radical. Actually, I would like to go forward one for you. That would seem radical. It might seem radical, but from a point of view, and I think better, I put these out of order, better from a global perspective, a comparativist like Dr. Piotrowski here, she would know that that actually fits really well with the contemporary human rights framework, which is focused on human rights rather than on the respondent entity and the ability of private entities in our country, especially since we've had waves of privatization since the 1980s, to affect individuals is profound. And so I suggest that if we're not talking about freedom of information vis-a-vis the private sector, then we're not really talking about the freedom of information. So I want to acquaint you with, I guess I can use this, but I don't know how. There you go. All right, so I want to acquaint you with a concept from Africa. And if you'll, to place this in some context, think about what we know about South Africa and apartheid and the reconstruction of South Africa that occurred after apartheid in the 1990s. And it was recognized at that time that private entities had a great deal to do with the perpetuation of apartheid. And so that was that acknowledgement was part of South Africa's reaction to that. And that's incidentally not unlike what happened in the United States. We got the 13th Amendment, and to some extent the 14th and 15th, though they were watered down by the 1883 civil rights cases, and we're still dealing with the aftermath of that. But now we're talking about a more recent experience. And in the South African Constitution in 1996, FOI was constitutionalized, as Anamarija said, not an unusual phenomenon in the world today, but it was provided that not only would there be an access of information held by the state, but access to information held by another person, as you say, any person, when required for the exercise or protection of any right. So I have to pause and say a nod to my literature review here, because I'm going to go on now and and steal ideas from people who've researched this before. And namely, I want to point out Richard Calland, who's the FOI person in South Africa and has written extensively for 25 years on the subject. And also Alistair Roberts, who I think spoke at one of your conferences, Suzanne, right? And he just joined my university system at University of Massachusetts and proposed an idea very much like what I want to propose to you today in 2001. Okay, so credit where it's due. But actually, let me say, since 2001, a good deal has changed. FOI has been built into the human rights framework. Data protection, as you heard Anamarija talk about, has attained human rights status as well. And as many of you know, FOI legislation has proliferated around the world. So there's a great deal to look at since this subject was addressed by Dr. Roberts in 2001. Now in 2000, just before Roberts' seminal article on structural pluralism in 2001, South Africa adopted its FOI statute, Promotion of Access to Information Act, PAIA. And that operationalized the constitutional provision from 1996. So this is now the FOIA for South Africa. And its Section 50 operationalized access to the private sector. And you see it has language that's very similar to what the constitutional provision contained. That was in 2000. After some years' work, the same principle was perpetuated in 2011 in a model law from the African Human Rights Commission. So that law has language that's a little bit different, and I'll compare these for you in a moment. But you see that that same principle, access to the private sector, now appears in Africa's model law 10 years after Roberts, 11 years after the South Africa PAIA. And then, perhaps not surprising since there's now a model law, Kenya's 2010 constitution was operationalized in 2016 to incorporate that same principle of access to the private sector. So we now have a couple of things going on. A phenomenon of access to the private sector sweeping Africa, I hope sweeping if it continues in this vein, slowly sweeping, but making movement in Africa. And we have a good amount of time, a decade and a half of experience looking at how this works. So we can start to make some judgments about it. And I want to acquaint you with a little bit of that. An interlude for a moment. I put together this table. I did it mostly for myself, but then when I thought it looked cool, I thought I'd share it with you. But it's loosely color-coded. But what I wanted to show with this is to try to make a case that we're behind. That our 1966 FOI Act is too old. It's not keeping up. There are three columns here. You've got access to information, statutory or constitutional on the left. In the middle, you've got data protection, specifically the right of access and correction for personally identifying information in the middle. And on the right, access to the private sector. And you can see here, if you can see it closely enough, a steady pace of progression occurring in different systems around the world, including Africa. And where you see the United States, all that red ink, it's at the top. It's in the old part. Where you see the United States carried down, it tends to happen in two ways. Over on the right here with private sector, it happens only through affirmative disclosure provisions as we try again and again to try to get it right in the financial sector and yet keep suffering crises. And then in the middle, it's where we're being dragged kicking and screaming by the Europeans to adopt some kind of privacy protection. So we piecemeal do it so we can get to the next safe harbor agreement. And that's really all the progress we've made while these other changes have been occurring around the world. So the literature on access to information, or FOI, has become really sophisticated in the last decade and a half, and the focus has described ATI as something of a third generation or new wave of human right, in that it is not a right in of itself, but it is a right that's a leverage right. It's not my term. I like it, though, so I took it. It's a leverage right, put quotation marks. It's a leverage right to achieve other things, namely socioeconomic development, the realization of socioeconomic rights, which are the second generation of human rights, as well as first generation human rights. And these are all the ways, the rights or aims in which this access to, really access, but also access to the private sector is envisioned to take place in the South African system. So I promised you that language would come back. Here you can see, so we're going to analyze how this is worked out. it helps first to compare the language, because that really points to what a couple of the issues are. There's not a lot of case law in the last 15 years. One of the problems South Africa's having is what we've talked about all day today, which is too many requests denied, and the only enforcement mechanism is litigation. In South Africa, there's not a lot of folks with the resources to litigate these abstract claims. So not a lot of cases, but some experience. And it's largely on these points. What is it to say that this record is required? What does required mean? And then what rights are they that we will exonerate? Despite those differences in language, we have a fair amount of precedent on that. Required doesn't mean required. It means reasonably required. And there's other language from the case law there. Significantly, I want to know from a U.S. perspective, this abrogates, if we're talking about access to the private sector, this abrogates neutrality as to requester identity and motive. The requester bears the burden of explaining why he or she wants the information and what for, and establishing the link. Alternative statutory or common law remedies are taken into account, as is the size of the business. I'll talk about that in a moment. And courts emphasize it's a case-by-case inquiry. What rights are they that we're exonerating? Well, South Africa has been really broad in interpreting this, and I gave you a sampling here with some case names in case one strikes your fancy. But you see administrative procedural fairness, which is kind of the APA roots of our FOIA. You see environmental rights, which are a socioeconomic right in the South African Constitution. That's versus a steel mill to get an environmental impact statement. There is even shareholder rights in the dissolution of a small business, and even contract rights. That Klaas case is a fellow who was fighting South Africa Airways over the terms of his retirement as a pilot. Interestingly, the South African courts have even, in my favorite case, M&G versus FIFA 2010 LOC, and this is how I came to this whole area, by the way. I was writing in sports law and discovered this case where M&G, as the Mail and Guardian, got access to the local organizing committee of FIFA 2010's World Cup to see how the money was spent. There was $500 million spent by the LOC in South Africa, a private entity. And indeed, the court awarded access to M&G, quite remarkably said, well, the journalist has to get access because there's a right to freedom of the media, and they have to get the story right. And they don't want to defame anybody, so we have to help them. Now, I think that really is extreme. Kenya, I should point out, backed off of that a little bit in an interpretation of access under its constitutional provision in 2011, said it can't be that you can bootstrap freedom of media to get anything, because then the whole thing of articulating your human right wouldn't make any sense. So it has to be something more than that. But it does give you a sense of how far the South African courts have gone with this principle. There have been access denied in some cases. There was access denied in a big case involving the African National Congress where these rights on the left were asserted, but they were just too far from justiciability, and South African courts said, really, especially when we look at the way other countries do things, the publication of private donations is really something to be handled by the legislature in the political process. And indeed, as a result of the case, even though the complainants lost, the legislature adopted transparency initiative in private donations to the political parties. Also, denial of access in one shareholder case, because the Companies Act provided a way for the shareholder to get the information. And also in a case involving healthcare, it's somewhat controversial in its outcome, but because they said the litigant really was just trying to get pre-action discovery in what would become a wrongful death suit on medical malpractice. So those are alternate avenue access situations. So what does all this mean to us in the United States? Mendel's 2016 survey had us as 51 in the world in terms of the efficacy of our FOI regime. Only a couple of points derive from access to private or quasi-public entities, but they do derive from those points, and we don't get those points. We're living under FOIA and an access to the private sector system still really based on the last 1974 amendment to agency records, which is really, really narrow. Forsum v. Harris, a case of denial of access to a government grantee, is still the go-to case. We've got those modest affirmative disclosures in sectoral laws, and that's it. Meanwhile, state and global norms have raced ahead using some permutation of finance and function test, significantly augmenting our control test. The place where you really see this play out is in prison privatization, something we've been talking about since the 80s. Perennially, there is a bill. There's the latest one. It's been referred to the Senate Judiciary Committee, where all its prior perennial brethren have gone to die. Mother Jones did a great piece on abuses in private prisons in 2016, and that piece was just nominated for a National Magazine Award. So I'll remind you quickly about these leverage rights, and I have a series of slides here I'm going to go through very quickly, but just to say, if you think this is just a thing about African development because the government's so corrupt and all that, let me just suggest how this could be used in the United States. Housing and banking sector, energy, Deepwater Horizon, water, which although Flint, Michigan was a public affair, now water systems are privatizing because they can't afford to replace the pipes. Remember that. The price of an EpiPen. 2028 Olympics, private-public partnerships are going to be required to pull that off in Los Angeles. Boston, where I'm from, Boston and Hamburg said no for some good reason. I didn't want to say anything about that, but the Orlando Sentinel just did a great piece at the state level on state money in private education. But I think there are federal implications as well. Environment, that's a Keystone, or Dakota Pipeline, pardon me. And then one of the biggest users in South Africa of the system is the South African Historical Archive. And we have, someone from National Archives, here. SAHA has been researching apartheid, because that was the point, right? To find out private complicity in apartheid. And, I wish this picture were taken in South Africa, but it's not. I think we could stand to learn, too, from some historical research into private actors. So what would this look like in US FOIA? I'll be quick, because I know I'm running out of time. But for one thing, I just want to point out, we already have some semblance of this. We have had for 30 years now affirmative disclosure of toxic releases. It's the same thing. It's just an affirmative requirement on a specific circumstance when a human right, health, safety is implicated. If you inserted South Africa's system into ours, I think that could work. It would have to run through the Commerce Clause, but that's not bad, actually, because I think if you aligned it with our security regulation apparatus, it would solve one of the problems South Africa has, which is the costs it imposes on small business. That wouldn't be a problem if it only affects publicly listed companies. What rights would we apply it to? We don't have to be as broad as South Africa. Our 14th Amendment concept of fundamental rights is fairly narrow. It would certainly get you liberty in a prison context or life in a private prison. And as for the required test, it strikes me that if you're going to start with a fundamental right, you could carry through and use our constitutional analysis of strict scrutiny and say that the release is narrowly tailored to what is required to accomplish exoneration of the right. I couldn't think of any objections. That's not really true. There are objections, but I think there's surmountable cost. With the Fannie Mae Freddie Mac bill, for example, GAO has estimated the cost. It's not a little bit, but it's a tiny fraction of the total operating costs of Fannie and Freddie. Corporate requesters, I worry a little bit about what Professor Kwako writes about with corporations becoming vicious and attacking each other. But Kenya just decided that, hey, it's an individual right thing. Corporations don't have access under this provision. And political feasibility, that's above my pay grade. There are a lot of other models out there to look at that could be partway steps between this and that. I think Jamaica has a really neat provision about the essentiality to the welfare of the people that can cause an entity in the private sector to be classified as a public body. India has a neat system where you can make a request of a public entity, and if the public entity has the legal ability to demand the information from the private sector, then it must do so. So it sort of triggers that private request. And then, of course, there's every permutation of finance and function testing, which is now, as I said, the norm in the world, Africa, Europe, the American states, and even Ireland, if you need to find the weakest function test in the bunch, even Ireland, trying to court Facebook et al., was able to find its way to a more expansive test than ours. I don't know what our new FOIA should look like after we blow it up. I'm not that smart, but I do think we can do this so much better. And again, if you need to read some dystopian science fiction to believe me, go ahead and do so. But you can start with Dune and end with the Hunger Games, but if we don't do something to balance the scales between people and our corporate overlords, we're not accomplishing freedom of information. Thank you.
Thank you. Well, you've certainly given us an entree into a discussion, even though you said you don't know if we blow it up, how will we rebuild? But there is, it's a very real question when you break something down, what does it look like when you try to rebuild it? And or even theoretically, what does a blank slate look like? And so as we look back on 50 years, it's also a forward-looking, and Dr. Piotrowski, when you said, what is the goal? And Dr. Musa, when you said, we're lacking the dialogue. So what does it look like? Where should we go from here?
Okay, I don't really know. I think Rick gave us a lot of things to think about, so did Anamarija. So if we are thinking about new laws, Mexico was at the top. Maybe you don't know, but Mexico has major problems with respect to implementation of their FOIA in civil society in Mexico, but that doesn't mean that their law isn't good. It means that they're having some serious problems with implementation and democracy. So we could look to some of these leaders. I also think what Rick was talking about, he does propose some things that are radical, and I'm fine with being radical, but there are also a lot of things that are currently going on that we could do better, like with respect to beneficial ownership, which is not necessarily saying we can FOIA, Coca-Cola, but to figure out, to have beneficial ownership. The concept is that people can really understand who owns a company, who benefits from a company. You're nodding. You could talk about it better than me, probably, but this is something that we're lacking. We're not leaders in the United States by any means. So having some sort of lists or access to truly understanding shell companies and who are benefiting from these companies, when you were talking about South Africa, Rick, I'm sort of not answering the question here, but with respect to natural resources also, right? This is one of the major issues when corporations are involved with removing and benefiting from natural resources. Where does that money go? How much goes back to the actual countries? I think that's something we could do a lot better with here in the United States, and there's very little dialogue about that right now.
Thank you.
Oh, thank you. Well, we switched maybe to the issue of privatized services and outsourcing, but before I say something about it, I mostly underlined that there are different models which evolved, and Richard also showed that United States were the first, and they have been the leader for a certain time. But in the meantime, the things changed a bit, and there are many other legal systems and political systems that introduced, I would say, better systems. As I showed, the 10 best ranking countries in terms of legal framework, not implementation. When you see, you would never say that these were those states. But the thing is that what America has, which might be better than in other countries, is the implementation of the law generally. So I believe once you improve your law, you'll be leaders for another 50 years. That's what I. With regard to privatized services, maybe two things. In most European countries, given the fact that we had to implement the EU directive on open data and reuse of public sector information, and this directive covers also all the authorities that perform public function or any privatized public services. So these entities are also covered by our laws. So for example, in Croatia, these are all publicly owned companies, like in energy or small communal enterprises, water management companies, which are owned by, let's say, 4 local governments. They're all covered by our law, and this is the similar situations in other countries. But when it comes to the private sector, what happens a lot is that requesters request the inspection or other investigation documents which regulators or any other supervision authority has, and they relate to any private provider of any service. So in this way, we also have like intrusion of transparency, I would say, in private sector. And with regard to beneficial ownership, I don't know if similar situation is going on in the United States, but what we have in Europe is that the EU has adopted the directive, 4th directive on money laundering and terrorism, fighting money laundering and terrorism. And in this directive, it envisaged that all member states should create a register of beneficial owners. Beneficial owners would be those people who have the influence on the company. It was in 2014. They didn't say that it should be transparent, this register. But what happened in the meantime is that is Panama Papers and other scandals that led the European Union to revise the directive, and now, as it seems, the new directive, the 5th directive, will be adopted, and it will require all the countries to open up these registers. My concern is how this register will look like. This is another issue. But already UK and few other countries have opened up their registers. So you can see, for example, that although the formal owner is, I don't know, person this and that basically the beneficial owner is somebody else. And this is very sensitive in commercial terms, but it's happening in Europe.
Great. We're going to open to the floor for questions after this last. And as the final panel, you get the last word for the day. And you've provided, you committed your life to research in the area of FOIA and to the practice of. So if you were each to leave us with something that if we walked away from this day, what would we really need to remember from it? What would it be?
I'll let you go first, Rick.
Oh man, no, I can't. I want to. I want to say how far behind we are, but I don't wish that to be understood negatively. Like, I mean, I'm patriotic, I swear. But I just wish we would take the lead again. It's frustrating to me. I don't like going to conferences elsewhere in the world and being lectured at by people who are doing it better. I'm going to go tell them how it's done.
Maybe that we should, I know we're here talking about FOIA, but we need to think broader than just FOIA, and that the point is not to have, the best litigation or the best, the best process with FOIA necessarily as defined here, but the broader concept of democratic governance, and that's really where we need to be looking when we go forward.
And that's not where we started.
I would say not only in the United States, but everywhere, more dialogue and more inclusive process of democratic governance, I would say, so I agree with you.
Thank you. Thanks for being put on the spot there a bit. So do we have any questions as we wrap up? Yes.
So this is a question for specifically the European context. Has there been any sort of discussion with the access to information and wanting more of that and more of the transparency within the legal system, especially because in most civil law systems, there's very, very, very limited discovery and kind of how those two ideas work with each other?
Yeah, it's a good question. I'm also concerned with that. There are some initiatives to open up judicial system more, because especially in civil law countries, there's no comparable level of transparency when compared to US. Here, you are definitely the best. But Well, privacy then comes in, and this affects the level of transparency and the different traditions within different countries. For example, in France, they open up. I mean, they're pretty open when it comes to judiciary. In Croatia, we are like not the best, but not the worst. But in some countries, judiciary is completely closed. Only maybe administration of courts would be open, but the cases and the documents are pretty closed, in the meaning that they're open up for anyone. Only researchers or media can, with a special purpose, inspect them. So this is another issue which is tangled in the EU, and I believe that within some time it'll be resolved.
Kind of rolling off of that question, if there were some legislative form of access to information for private entities in the United States, how do you think that would affect litigation in our system? Say in the context of discovery, where it could just turn things on its head, or it could make things much more efficient. What do you think would happen there?
Yeah, I think it's, we heard something earlier today, and let me be clear, I'm not a federal FOIA expert. I just play one in the classroom. And I heard something today about FOIA being used by a significant but not substantial number of persons as pre-action discovery for civil rights, which makes sense, right? Because the defendant then is going to be the government. And that's what I see happening. Because, of course, in the South African model, it would be limited to human rights-based, or what we call civil rights-based rationale. And so there would be pre-action discovery, essentially, is what it would be. And I think that's healthy, honestly, because I think that leads to meaningful litigation rather than fishing expedition litigation, and a lot of non-litigation, because a lot of times people just want information. That's what they really want to win in the litigation. So I mean, that's a modest, fast take, but I hope it's something.
We have time for another?
So I'm sorry, Anamarija, you put Mexico at the top of the list, right? As like being the most transparent. Mexico's a failed state.
Yeah, of course, yeah.
It's a complete disaster. I sound like Donald Trump, I'm not saying if we build the wall, but it's a failed state. And so what do we mean to say in the abstract that they have the best laws in the world if they'd only implement them? I mean, so it seems to me that you could write this amazing set of laws that people can just completely fail to implement. In what sense is it number one? It seems like you need a system that can be readily administrable and implemented. And so I guess I wonder, is there some ranking that combines the law and the culture of sort of compliance? Because formally speaking in the U.S., I agree with Rick, we're behind. Formally speaking, the Freedom of Information Act only applies to Article 2, it doesn't apply to Article 3, it doesn't apply to Article 1, and it only applies to a limited part of Article 2, the executive agencies. But we have things like common law rights of access, to Article 3 to courts. We've got all these affirmative disclosures that are done, to be sure, as a matter of grace in policy decisions that occur by the judiciary. You can get all kinds of statistical information from the Administrative Office of the U.S. Courts, the Federal Judicial Center, so PACER. I mean, it's very transparent, and none of it is sort of, well, maybe some of it is statutorily mandated, but I think most of it is just a matter of grace. So do we have any kind of ranking that takes into account this kind of like the culture plus the legal system? Because I'm going to guess that the U.S. isn't quite as dismal as you guys are making it sound.
I said that it's not. I said that these 10 countries would not be considered the most transparent in practice, and that's the issue here. So imagine if United States improved some elements of its law, which were mentioned today as a problem. So, for example, first-person requests, they create backlog, and I suppose there are other ways to obtain your own documents. Maybe more effective mechanism which would save, basically made access to justice easier. So in terms that you don't have to go to court and pay for fees and stuff. So there are many issues, many, let's say, elements in other laws which could serve as a way of improvement. But I would say then a new leadership would emerge, in the meaning that the system as it is in the U.S. and what I have to say, and I didn't say that, compared to what is requested here in the United States, we are little babies. Here in Croatia, people don't request for such a sensitive documents. And if they were, I mean, Croatia is not that important. So nothing would happen behind our borders. Yeah, okay, it is, but it's not that important in global terms. So that's what I'm saying. There are some comparative advantages you have over all other countries.
So I want to rescue my earlier critique, and maybe I should have led with that. The idea is that, to me, is that we do have the grandest tradition of openness. Right? We took the British common law access principle and then eliminated the interest requirement. I mean, we invented that. And so that's what I want to see, the statutory framework that lives up to that legacy. But you're quite right, and I just point out, I mean, by way of example of your principle, that when you look at I'm so skeptical of the surveys, even though I played with the number 51, because when you look at the surveys of Africa, you always see Zimbabwe at the top, and then there's an asterisk that says, but it's not really enforced. So, or it's actually used to preclude access, because they've kind of gone with the exemptions, but not with the access part. So yeah, it's all, that surveys can be smoke and mirrors, and what matters is tradition.
I'll just answer also, no, there is no good measure. I mean, I've looked, a lot of scholars have looked, a lot of empirical scholars, you know, it's like measuring, you know, is a place corrupt? How do you measure that? You know, by the number of people in jail, by the number of lawsuits? I mean, how do you measure who hasn't gotten caught? I mean, there's no way, and it's not dissimilar in transparency. Perceptions, there's no good measure right now. I've looked, everyone's looked, people pull things together. The Open Government Partnership has all sorts of data on their commitments. They get stars, they don't get stars, if they're done or not. Sadly, I know how the sausage is made. I have very little confidence in the data. So I don't think that's where we need to be looking also. I would say, you know, Archon Fung, he wrote on some of this, and there are these waves, there are waves of laws, right? And so FOI, the US was a first wave. And then there was a second wave, and I think, as you were saying, we're on a third wave now, and it's very natural. You have a law, it's progressive, and then it gets clawed back. So I don't think this means we're dysfunctional in any way, but nor does it mean we can't try to, you know, look at extending FOI to Congress or the White House or the judiciary. I mean, it's just because we aren't doing it now doesn't mean we shouldn't think about these things. And I would push back a little bit, like, yes, Mexico is in many ways, it's not working right there, right? You know, civil society in Mexico is pulled out of the OGP because of all their surveillance issues, right? I mean, there are problems there. But it doesn't mean we can't look at the laws and say, what are some good ideas that we can borrow?
Yeah, it also just kind of strikes me that potentially the groundswell for change will be at the subnational level, so potentially locally up, because citizens now are very much issue-based, and I think of it as there's government reform and progressiveness about transparency, and I think we're at transparency plus, which means citizens actually want to be part of the decision-making. And is that potentially a way that changes to the goal of, you know, how you started with FOIA? Does that translate back up to the federal government as a groundswell? Because right now, you know, in terms of a reflection back on the day, those that are using FOIA right now, the private sector, individuals that should be getting information for themselves easily from the government anyhow without having to go through FOIA. So if this is really truly to be a democratic issue and a fundamental right, it's got to come from somewhere, and that usually comes from the people.
I guess that was my cue. I'll keep this short because I don't want to stand in between you and all the traffic on 95, but let me thank our Law Review staff for all of your help. Thank you, Professor Samahan. Of course, thank you to our panelists and our moderators, and we hope to see you again at Villanova Law soon. Thank you again.